Strata Reform will introduce a new transparent process to terminate schemes. Currently, there are three ways to terminate a scheme under the Strata Titles Act. The first way is by unanimous resolution of all owners. Another option is for one owner to apply to the District Court for an order deeming that a resolution to terminate the scheme was unanimous, provided that a special resolution to terminate was reached and the owner applying to the court was part of that majority. The third option to terminate a scheme is that one owner or one mortgagee can apply to the District Court for an order to terminate the scheme. These options have all proven to be complicated and costly. The current ways to terminate a scheme do not require a detailed termination proposal to be given to all owners and provide no safeguards for owners. The District Court is given no guidance under the Strata Titles Act on how to decide on a termination application. The reforms to termination will address the problem of ageing strata buildings becoming too expensive for owners to maintain, and will enable owners to terminate the scheme and receive fair market value for their apartment before the building becomes unsafe. The reforms will also introduce a transparent process, provide safeguards for owners, and require a full procedural and fairness review to be undertaken before a majority termination can proceed. Termination of schemes is more than just a vote. It is a whole process. The vote is only one part of that process. The termination process that must be followed if an owner wishes to terminate a scheme is firstly an owner called the applicant who wants to terminate the scheme must prepare a detailed proposal. That proposal will contain the sort of information every owner would need to make an informed decision on whether to terminate a scheme. Secondly, the applicant must serve the termination proposal on all owners, all mortgagees, and on the strata company. Next, the owners must be given at least 3 months to consider the proposal before any vote is taken. After waiting at least 3 months, a general meeting can be held, and that meeting must be properly called. At the general meeting, a vote must be properly taken. If the proposal is supported by the required majority and the applicant still wants to terminate, the applicant must then submit the proposal to the State Administrative Tribunal, or SAT, for a procedural and fairness review. The vote required to ratify a termination proposal before a SAT review is for schemes of 4 or more lots. 75% of lots must vote in favour. For 3-lot schemes, at least 2 lots must vote in favour. For 2-lot schemes, at least 1 lot must vote in favour. For leasehold strata schemes, 75% of lots and the lessor must vote in favour. For community title schemes, 75% of all lots must vote in favour. If the required vote is attained, the proposal must then be reviewed by SAT. No majority termination can proceed without an order from SAT. SAT can only order that a scheme be terminated if SAT is satisfied of 3 key things. Firstly, that the termination process was properly followed. Secondly, that every owner will get fair market value for their apartment. And finally, that the proposal to terminate is just and equitable. To decide whether the proposal is just and equitable, SAT is to consider these things. SAT must consider the views of every owner and every mortgagee. SAT must consider if there is a more appropriate order, such as that the strata company should repair the building instead of terminating. SAT may consider the condition of the buildings and the cost to maintain the buildings. SAT may consider whether a different vote would have been obtained if votes were cast using unit entitlement instead of just a show of hands. SAT may consider the use of proxies and whether they have been used in the best interest of the owner. SAT may also consider the impact of taxes and stamp duty on owners. The termination proposal must provide certain levels of compensation for every owner. Firstly, every owner must receive fair market value for their apartment, which means they must be paid the open market price for their apartment. The applicant seeking to terminate the scheme must also pay owners for their removal expenses if the termination means they have to move house. If a strata owner is running a business on their lot, the applicant must pay compensation for losses to the business caused by relocating as a result of the termination. The termination proposal can also include an offer to provide the owner with a replacement apartment. Landgate understands the importance of protecting people's property rights, so the majority termination reform will provide safeguards for all owners. Additional safeguards will be provided for vulnerable owners. The applicant seeking to terminate a scheme must provide funding to vulnerable owners to properly respond to the proposal. Vulnerable owners can use that funding to pay for legal advice on the termination proposal and obtain legal representation during the SAT hearing. They can use that funding to pay for expert reports and advice on valuation, taxation and other financial implications. The regulations will define who is a vulnerable owner. If there is any dispute about whether someone is a vulnerable owner, SAT will decide who is a vulnerable owner.